everybody, this is Tracy here with another edition of A View from Tracy's Point. And we are here with another R. Kelly update. And so I haven't really been covering this story as much as I have in the past. And so to kind of just pick up where we are right now, R. Kelly was arraigned for like the third time in the Eastern District of New York, another superseding indictment. And so Anton was away from the court. She has not been replaced as the judge that I am aware of. She's still on the case. And so there was a magistrate that was sitting in, and the magistrate, I think, is like the head judge in each division of the federal court or what have you. And so this, I guess, would be like Ann Dunleavy's superior if you look at it from a managerial standpoint. And so this person sat in on the arraignment last week. It was a very short arraignment, and basically R. Kelly pleaded not guilty to the new superseding indictment. And so a couple of people had asked me, you know, what were the new charges or who were the new alleged victims in the superseding indictment. And so there are no new victims in the superseding indictment. Basically, if you go back to the previous indictments, you'll see that under the racketeering charge, so there's 5 or 6 counts on the Eastern District of New York indictment. The first count is the racketeering charge. And so under that racketeering charge, there is numerous like sub counts, I guess. I don't know how you would really categorize it, but they're basically laying out their points of what each allegation is, what codes under the RICO Act that they are charging him with, and then a brief description. So if you go through all of those, and I can't remember how many it was, maybe 9 is in my mind and 13 is in my mind. So there were either 9 points under that count 1, or there were 13. There was some number. And so within that number, there were 4 paragraphs, 4 points, 4 letters, however you want to put it. And those apply to Jane Doe number 5, which we know is Azriel Clary. So in this superseding indictment, what they did was they took those 4 points under the racketeering count, which was count 1, and then they created counts 2, 3, 4, and 5. And they basically are now, in addition to count 1 allegations, they're basically adding 4 more counts to the overall indictment. And those 4 counts are breaking out those points from the racketeering charge and making them individual counts, if that makes sense. And so they took those items, they made them their own separate counts, and I think they may have added a sentence or two to the original text to make these counts, I guess, stronger. But they're basically the same information that was in the racketeering charge, and they've just, you know, just adding on to these charges. And we all know at this point, they are basically doing whatever they can, trying to break his spirit, trying to break him down and make him want to plea out in order to get out of jail or to get all of this over with. And so a lot of news outlets were reporting that there were 2 new victims, that there were new allegations. There are no new allegations. It's the same information that was under the count 1, which was racketeering. That same information, they've just added counts against him. And so by putting Jane Doe number 5 as count 2, 3, 4, and 5, that then pushed down the counts that were there under Jane Doe number 6, which we know is Faith Rogers. So whereas Faith Rogers was initially, I believe, counts 2, 3, 4, and 5. She's now counts 6, 7, 8, and 9. And so they really didn't make any changes to Faith's information. They may have clarified some wording or whatnot, but there's nothing new in this superseding indictment. It is basically the same information. They're just pulling stuff out of that racketeering charge to create new counts to make the overall indictment seem like is, like they're really coming from him, for him. They, come across new information and all of that. And so speaking of the superseding indictment, I find it interesting in the response to the opposition to bond that came out today that I'm going to go over with you guys, is that they, kind of like, oh, this is the third time he's filed a motion to get out, nothing's changed. And so they're acting like, oh, they're getting on their nerves because they keep filing these motions to try and get him bond. But they don't think that they're getting on the legal team's nerves by keep coming up with these superseding indictments that are really nothing new. You're not adding anything on. You haven't uncovered any new information. You're just rewording the original indictment and just trying to make it seem like it's bigger and better than what it was before, when it's basically the same information that was there all along. And then the other thing I wanted to say, a lot of people seem to think that, the little gimmicks that Azriel is pulling, the whole video that she did last week, where she's saying that, she's going to tell her story. She's going to not only tell her story, but she's going to tell everybody else's story also. That, the things that Azriel is doing with the Photoshop pictures and whatnot, they think that that is what's keeping the judge from giving R. Kelly bond. I don't think that that's what's keeping them. I think that they have made up in their mind that they're not going to give him bond. And it doesn't matter what Steve Greenberg or the other attorneys write in these motions. They don't want to give him bond. And I don't think it has anything to do with Azriel. I don't think it has anything to do with the stupid stuff that she's doing. I just think that they've decided they don't want to give him bond. And no matter what, if they can write a strong enough response, opposition to what Greenberg is submitting, then the judge is going to go along with the prosecutors, with the, the state attorney or the U.S. attorneys in this matter. And so it's just a tug of war. And basically, every time they come out with these superseding indictments, then the defense has the right to request a new bond. And we saw that under the magistrate who heard the arraignment last week. She asked them, okay, so are you going to be submitting a new request for bail? Because that's part of the procedure. Like every time you get arraigned, you get to ask for bond. And so for them, the Eastern District of New York to be like, oh, they're agitated, they're annoyed that he keeps trying to get out is crazy, and it's very condescending. And so in Greenberg's motion last week, he filed this on Friday, because when they did the arraignment on the 30th, they stated that they had found out that R. Kelly had had a medical exam back on March 30th or March 31st. And that they had the jail had the results of the medical examination on April 1st, but they didn't share the information with his legal team or with R. Kelly until April 29th. And then the arraignment was on April 30th. And so they felt that they hadn't had time to review the information. And so they would file their motion at a later date, and the judge was okay with that. And so the motion was actually filed on Friday, which was May 1st. And so this is what the motion stated. It says, Dear Judge Donnelly, we respectfully request that you revisit your decision denying Mr. Kelly bail. Doc 61. For one, he has a legitimate health risk that was being secreted from him by the Bureau of Prisons, who failed for the past month to disclose that March testing revealed he is likely diabetic. In addition, the ruling unfairly skews things against Mr. Kelly, completely failing to recognize any of the facts that show, even more so now in the current quarantine environment, that he is neither a risk of flight nor a danger to the community. The ruling does not appear to consider whether there are any set of conditions which could reasonably assure the court that he would appear and would not be a danger to the community. We are again asking for release during the pending crisis, given the increased health risk in an incarcerated situation, i.e. being incarcerated creates its own high risk. So for those of you that are new to all of this and wondering what's going on, you know that we're under the COVID pandemic that's happening around the world. And there are certain cities that are being impacted more than other cities in other states. And so Chicago is one of those cities that's being heavily impacted with cases. And so when they filed one of the motions that they filed, they cited COVID because all these people are getting released. Like Michael Avenatti was one of the people that got released because of COVID. And so they're saying that if the person has a pre-existing medical condition, then they are eligible to be released. That's one of the ways that they could be released. And so they put forth their motion citing, why they wanted him to get out. And so one of the reasons the judge denied the previous request was she was saying that they didn't demonstrate that he had any health risk. And so as all this back and forth is going on, the numbers at the MCC Chicago, which is, I think it's Metropolitan Correction Center, which is a federal holding jail in downtown Chicago, the numbers are like just going up. And of course, they're like basically doubling as time goes on. And I believe there's don't quote me on this, but it was either 45 inmates or 145 inmates in one article that I read. Like I said, don't quote me on that number, but I do know when they filed the first motion, they came back and said that there were no prisoners that had been impacted. And then when they filed the last motion, there was 23, or the number was growing. So there were inmates that were impacted. Somebody that was on his floor had actually been hospitalized, and it came out that 2 people on his floor had been hospitalized. It might have been 32 inmates and 23 staff members had tested positive for COVID. And so now that number is even higher today. And so they're basically saying unless he has these underlying health issues, like Michael Avenatti, they said had pneumonia 6 months ago. So that put him at a health risk, and that's why they let him out. So now they're trying to demonstrate, now that this physical had taken place, that yeah, he does have a health risk, and this is why you should let him out. So then it goes on to say the court previously noted that the information regarding Mr. Kelly's health and risk factors had not changed or demonstrated he was a high risk. Yesterday, during a court-ordered telephone conference with Mr. Kelly, he explained to counsel that he had just been brought the results of medical tests that had been done in March, a month before. The BOP had the results on April 1st, but did not share them with Mr. Kelly until yesterday, April 30th. The information showing he may be high risk was withheld from him and thus could not be shown to or considered by this court. And it says, Then it says the test reveals that he is 1/10 of 1 point below diabetic at the very top of the high risk category. It is a fact that people who are diabetic are at a much higher risk of serious complications should they be infected with COVID-19. And throughout this motion, they are citing newspaper stories that I thought that was kind of, I wasn't sure about that move, but they're basically citing as their proof or record are newspaper articles from like the Chicago Tribune. They have an article from the CDC.gov. And so they say he also suffers from high blood pressure and cholesterol issues. These conditions also make him a higher risk for bridging the 110 and having diabetes, as does the fact he's overweight. A copy of the results is attached. In the current environment, they are not taking any medical action to mitigate any of these conditions. They let a month pass before sharing the results. It only makes sense that given the absence of any knowledge on his part or any mitigation, that he is likely now diabetic. And of course, African Americans are at higher risk when infected with COVID-19. How risky it is within the correctional institution where he is housed is uncertain. The institution itself has either unintentionally miscounted or intentionally misrepresented the amount of cases they have. The numbers have swung wildly up and down. They have been posting on the public website numbers that are significantly lower than prosecutors have announced in court. See Chicago Tribune, wild swing in coronavirus numbers reported as Chicago's federal jail goes unexplained, leaves lawyers skeptical. And so that's a quote from this article that they're citing. And then it says, just days ago, they claimed there were only 6 cases, and now that number is at least 48. The number is also likely understated since many have gone untested. It has been reported that the rates within the Bureau of Prison Facilities are artificially low because of a lack of testing, with 70% of those who are tested coming back as positive. See Associated Press reported title, over 70% of tested inmates in federal prisons have COVID-19. And then in parentheses it says, a quotation, and even though officials have stressed infection and death rates inside prisons are lower compared with outside, new figures provided by the Bureau of Prisons show that out of 2,700 tests system-wide, nearly 2,000 have come back positive, strongly suggesting there are far more COVID-19 cases left uncovered. The fact is that it appears that there is a serious spread within the Bureau of Prisons and this institution. The court's opinion refers to curtailed capabilities and oversight. If Mr. Kelly were released, it would be in the Northern District of Illinois. To the best of counsel's understanding, no court in this district has denied release because it would be difficult to monitor an individual on bail. Indeed, in the wake of the pandemic, the chief judge for the Northern District of Illinois released a high-ranking gang member who had been held without bail as a danger to the community, noting that the world to watch he was being released was far different from when he was first arrested, and notwithstanding the fact that he had already pled guilty to his offense. Equally troubling in this court's embrace of a belief that Mr. Kelly is a risk to flee and obstruct justice, Mr. Kelly must also present a serious risk of flight or of obstruction, not an ordinary risk. See also United States versus Friedman, and you guys know sometimes they throw in this case study that they claim is precedence for, what they're trying to do. And so it says to suggest that he is a serious risk or either, with all due respect, ignores the fact, instead relies upon speculation unsupported at best. And then, they go on to repeat that at his former trial back in 2008, he was awaiting waiting his day in court for like 6 or 7 years, and he didn't try to flee. He showed up whenever he was supposed to. He was where he was supposed to be at all times, and he didn't try to flee. And so they don't feel that should, they feel that should be taken into account, that, he was facing significant time back then, but he wanted his day in court, and he wanted to have the evidence presented against him, and he was found not guilty in that case. And so it says that during the earlier state prosecution, Mr. Kelly was allowed to travel out of the country and return. The government keeps claiming that he obstructed justice in that case, implying that is the reason why he prevailed. But the fact is that there was a 3-week trial with dozens of witnesses, including some of the same witnesses that are involved in the federal proceedings now pending. Mr. Kelly was very much at risk of going to jail during those proceedings, and still he showed up. He did not flee when he was charged in state court in 2019. Rather, he turned himself in after he was asked to. And he would have done the same here had he been given the opportunity. Further, the government has not presented evidence that Mr. Kelly has any resources to flee, regardless of what he is receiving in royalties. That does not translate into resources. And so what they're talking about here is in the last response, the last opposition that the prosecutors presented, they talked about the fact that he's still getting $200,000 in royalties. And I believe he gets his royalties twice a year, every 6 months. And so he's still getting his royalties. And so they were claiming that, that would, he would have money to flee. But then in the response that the defense gave, they talked about the fact that he owes $65,000 in back taxes from 2013, and then his new tax bill that would have been filed this year is like $1.8 million or some number like that. And so Greenberg is basically saying that the IRS has this lien on him, and so it's not like he can access a bunch of money. He still owes his child support. He's still paying. He still has people on his payroll that he's paying. He's got to pay his legal fees. So he doesn't have money to flee. And so they go on to say they cannot point to a single individual that would attest he is ever expressed any desire to flee. They cannot point to a single email or text message. Where would he flee to? He would be noticed, wherever he would go. And how would he have money to survive if he did flee the country? And so courts routinely point to a defendant's failure to appear a prior proceeding as a reason why they should not be entitled to bail. If that is the case, then the opposite should be true, that a defendant's appearance in prior proceedings should count for something. And then also them talking about him having the means to flee. We look at Michael Avenatti, who had just been found guilty, who's supposed to be sentenced on June 17th, who's facing like 2 or 3 more trials that he has to go through. And they released him, to go stay with some wealthy friend of his. And I'm sitting there thinking that Michael Avenatti done had a taste of what prison is like. Like, there is no way that man is going to willfully return to jail after the whole COVID situation is over and done with. And I think they released him for 90 days. And after 90 days, he has to report back to jail. And I'm just thinking, I'm waiting for the headline to break, basically saying that Michael Avenatti has fled, or Michael Avenatti has been rearrested because he was trying to move money, trying to get a fake passport, trying to get somebody to fly him out of this country on a private jet, because I just don't see him willfully going back to prison on his own. And so it goes on to say courts routinely, I just read that. So it says any suggestion that he would flee also flies in the face of the reality that it is virtually impossible during the pandemic to fly anywhere, let alone to do it surreptitiously. Airports these days are completely deserted. He could not just walk through an airport undetected or sit on an airplane unnoticed. He does not have a passport. And then they quote a story about empty airports. And then it says certainly conditions could be found that would ensure against any risk including GPS or electronic monitoring, which would give instant notification if he left any premises. And then it says the fact that there is no evidence he would flee, and historically he has not, should be considered with the speculation that he would obstruct justice. The government has repeatedly cited that factor, and the court has repeatedly embraced it. To deny relief, Mr. Kelly must present a serious risk of obstruction. Mr. Kelly's past behavior in this case shows that he is unlikely to obstruct justice. One of the alleged Jane Does until recently was Mr. Kelly's girlfriend. And I'm so glad that they finally pointed this out in one of these motions. And then also, I wanted to share with you guys about these motions. Like, a lot of times people are talking about these motions and, they're, getting angry, saying that Greenberg isn't doing enough. And I probably have been one of those people that have said he isn't doing enough, or I don't like the way that he's wording the motions and, putting the part in about he's going to stay with Jocelyn and, his ex-girlfriends, his 2 girlfriends and all of that. But it is important, and I don't know if Greenberg is like reading comments that people are making on social media, if he's watching videos, because it seems like, we'll put stuff out and then all of a sudden when he writes his next motion, he will kind of like pick up some of those things. But the important part about the motions that are filed in these cases is that, when you get ready to do an appeal, if an appeal needs to take place in the event he's found guilty on any of these charges, then they can go back and cite some of this stuff that is put in these motions. And so that's why it's important for him to be, challenging discovery, challenging all of these arraignments, constantly putting in these motions and adding more information, because it may be useful down the road in the event that they need to file an appeal. And so it goes on to say, although completely out of the norm, even though she was a supposed victim, she was regularly allowed to visit with him while he was in jail and correspond with him. It appears that during the approximately 6 months she regularly visited with him, corresponded via letters, shared emails, and spoke daily on the telephone. While he certainly knew that she was one of the Jane Does, he never did a single obstructive thing. Given that she is cooperating with the government, one would think if there was any evidence of obstruction, the government would cite to it, and it has not. And so Greenberg contradicts himself a lot, because here in this motion, he's talking about Jane Doe number 5 has shared emails with R. Kelly since he's been locked up. However, he previously said that R. Kelly doesn't have emails. So, when he does things like that, it is kind of annoying. It's like, dude, can you remember what you said the last time? Because they probably just picking apart and, jotting down these inconsistencies in your own statements that you're making about your client. So then it goes on to say, frankly, the idea that Mr. Kelly would now obstruct anyone is folly. The government has disclosed little evidence revealing the substance of their case, but what is known is that individuals are cooperating with the government and have absolutely no contact with Mr. Kelly or anyone associated with him. It says that is not the case with respect to all the Jane Does. The government has not disclosed the identity of 2 of them. One is his former girlfriend, who is continually on social media along with her parents, and then in parentheses, and there is no evidence that he or anyone on his behalf has reached out to her, in the parentheses. Another is represented by counsel, has sued Mr. Kelly, and has appeared in Surviving R. Kelly 2, telling her story, making it extraordinarily difficult to believe that even if he wanted to, Mr. Kelly could change her narrative. Another is deceased, and he has not had contact with the others, and the deceased, you know, is Aaliyah. And so it says, if ever, for more than a decade. As for the now former girlfriend, she was still his girlfriend when he was arrested in this case. And although the norm is not to allow a federal criminal defendant to have any contact with witnesses in the case against him, she was allowed to have special visits with him while he was in federal jail. They regularly communicated by phone and email. He knew that she was one of the Jane Does. There is no evidence he ever tried to obstruct or influence with respect to her portion of the indictment. If he did not try to obstruct or influence his own girlfriend, then how is it at all credible that he would do it to someone else in the future, which is where the focus is required to be. Then lastly, it should be noted that the two co-defendants in the Northern District of Illinois, including the supposed mastermind, were both released on bail without objection. These co-defendants have the same criminal history as Mr. Kelly, face similar charges, and have far more money. To the point, the law speaks to the future, i.e., quote, a serious risk that such person will, end quote, not that they have been, not that they have been. And so he's basically saying that you can't look to future behavior, you can only look at past behavior. And they cite a court case. And it says, regardless of the past, any evidence or concern of future obstruction is unsupported, notwithstanding years of rumors that Mr. Kelly was being investigated, television shows dragging him through the mud, and the filming of serious charges earlier this year in Illinois State Court. The government cannot identify any instances where Mr. Kelly has tried to influence, intimidate, or tamper with a single witness or potential witness to obstruct any current prosecution. What is most troubling from the defense's perspective is that this court accepts the allegations regarding obstruction as true and as evidence that he would obstruct now if released, but completely discounts the factual and historical evidence of appearance. Accordingly, we ask that you reconsider, because there are conditions that can be fashioned during the pandemic. Mr. Kelly is presumed innocent. His case is defensible, and he does not have any criminal record. Even when the government has satisfied its burden, detention should be ordered only if no condition or combination of conditions can reasonably assure the defendant's presence and the safety of the community. The question is whether there are any conditions that would permit release. Here, conditions can easily be fashioned. He can have restricted internet access and be required to wear an electronic monitoring bracelet. He can, I think it's a typo here, he can be denied. Further, now that different jurisdictions are involved in prosecuting Mr. Kelly, it is safe to assume that any witness that Mr. Kelly would attempt to intimidate would immediately call whatever law enforcement arm has been working with them as part of these prosecutions. In this case, any alleged potential risk that should conceivably exist can be sufficiently addressed through detailed conditions of release. Thank you again for your consideration. Respectfully submitted, Steve Greenberg on behalf of Mr. Kelly. And then they also attached to this his the medical report from that physical that he had. Of course, they black out a lot of information. They give, like the numbers that are associated, like with his cholesterol and, the high cholesterol, the low cholesterol, his blood count and other stuff. And I guess you would have to be a medical professional to understand those things. But basically, borderline diabetic, they talk about his high blood pressure and the cholesterol thing that was going on. So that was Friday, and then today the government filed their opposition. Of course, they would, saying that they oppose, to him being released. And so their response was 15 pages long. And I'm going to probably just skip over a lot of this. Basically, dear Judge Dunley. And so they're basically saying, this is the third motion for bond because of COVID, based largely on the defendant's claims that he has a legitimate health risk, namely his recent diagnosis of prediabetes, which purportedly places him at a higher risk of serious complications if he contracts COVID-19. Part of these prosecutions. In this case, any alleged potential risk that should conceivably exist can be sufficiently addressed through detailed conditions of release. Thank you again for your consideration. Respectfully submitted, Steve Greenberg on behalf of Mr. Kelly. And then they also attached to this his the medical report from that physical that he had. Of course, they black out a lot of information. They give, like the numbers that are associated, like with his cholesterol and, the high cholesterol, the low cholesterol, his blood count and other stuff. And I guess you would have to be a medical professional to understand those things. But basically, borderline diabetic. They talk about his high blood pressure and the cholesterol thing that was going on. So that was Friday, and then today the government filed their opposition. Of course, they would, saying that they oppose, to him being released. And so their response was 15 pages long. And I'm going to probably just skip over a lot of this. Basically, dear Judge Dunley. And so they're basically saying, this is the third motion for bond because of COVID, based largely on the defendant's claims that he has a legitimate health risk, namely his recent diagnosis of prediabetes, which purportedly places him at a higher risk of serious complications if he contracts COVID-19. And then, they're citing, where in the motion, in Greenberg's motion, she can find this information. And then it says that the defendant further claims that this court should revisit its prior rulings denying release, particularly in light of the pandemic, because there are facts demonstrating that he is neither a flight risk nor a danger to the community. As set forth in more detail below, notwithstanding his recent diagnosis, the defendant has failed to provide a compelling reason warranting his temporary release. Moreover, the defendant likewise fails to rebut the presumption that the defendant poses a flight risk and a danger to the community. Accordingly, the defendant's motion should be denied. And so they're talking about him rebutting the presumption that he poses a flight risk. I mean, first of all, he's never tried to flee. So what is it that they want them to argue? He doesn't have a passport. He doesn't have money. I mean, the only way that he could flee at this point is if some wealthy person who has a private jet who can go above the aviation authority and fly that private plane out of the country and then get another government to allow them to fly the plane into their country. Like, that is the only way that he would be able to flee the country. And since he does not have a history of fleeing, what is it that they're supposed to be rebutting other than the theory or the notion that he would flee? And so it goes on, it says, Roman numeral 1, relevant background. the permanent order of detention. So now they're saying that on August 2nd, 2019, after holding a detention hearing, the Honorable Stephen Tisicion, magistrate judge in the Eastern District of New York, entered a permanent order of detention against the defendant pending his trial. So now, and then they note where it was in the, what minute it was during that hearing. So it says that during the hearing, Judge Tisicion found that given one, the nature of the charges against the defendant, which at the time spanned from 1997 to 2018 and included allegations of sexual abuse of minors, coercion of minors, and child pornography. 2, the defendant's history of similar allegations. 3, the defendant's opportunity to flee given his access to financial resources. 4, the defendant's incentive to flee given the seriousness of the charges in the District of the Northern District of Illinois, the defendant's potential obstruction in his prior trial and potential obstruction in his prior trial, and the strong possibility of witness tampering if he were released. And 6, the fact that certain of the alleged crimes took place while the defendant was on bail during his previous trial. The defendant cannot be relied upon to comply with the condition of release. September 30th, 2019, detention hearing. Then it says, Judge Tisicion therefore concluded that, quote, no condition or combination of conditions will reasonably assure the appearance of the defendant and the safety of the community, end quote, and ordered the defendant, quote, to be detained pending trial. And then on October 2nd, 2019, after reviewing briefing on the issue and holding oral argument, this court affirmed the order for detention October 2nd, 2019, and then it tells where that information is found. Then it says B, the court's denials of the defendant's motions for temporary release. On April 7, 2020, the court denied the defendant's March 26, 2020 emergency bail motion. And then it tells why they denied it. Go down, it says the court further noted that the defendant is 53 years old, 12 years younger than the cohort of older adults defined by the CDC as at risk for severe illness. And so they're basically saying that it's really people in their 60s that if they get COVID, they have a higher risk of dying. And because he's only 52 or 53, he doesn't fit that category. Then it goes down and says on April 21st, 2020, the court denied the defendant's renewed emergency motion for release. The risk associated with the defendant release have not changed. Specifically, the court found that the defendant continued to pose a risk of flight because, among other things, he is now facing serious charges in multiple federal and state jurisdictions, blah, blah, blah. The court further emphasized that the conditions suggested by the defendant to mitigate his risk and obstruction are inadequate. And so they were basically saying that even if they did the GPS monitoring and all of that, that I guess because of COVID and everything that's going on, it would be hard to monitor him and that he could slip through the cracks and nobody would know. And that was one of the points that was made in the last denial. So then Roman numeral 2, discussion. In the motion, the defendant argues that the court's previous ruling denying the defendant's motion for release unfairly skews things against Mr. Kelly completely, failing to recognize any other facts that show, even more so now in the current quarantine environment, that he is neither a serious risk of flight nor a danger to the community. In defense of this position, however, the defendant sets forth the wrong legal standard, asserting the question is whether there are any conditions that would permit release. The motion, however, requests temporary release as a result of COVID-19 pandemic. The actual question before the court, therefore, is whether the defendant has presented a compelling reason to grant such temporary release under United States Code 18 as set forth below. To greater detail, the answer to that question is no. To the extent the defendant also seeks reconsideration of the court's prior findings that the defendant poses a risk of flight and a danger to the community with respect to the detention determination made prior to the irrespective of COVID-19 pandemic, the legal standard asserted by the defendant remains incorrect. The defendant is, of course, afforded a presumption of innocence with respect to the charges in the case. With respect to pretrial detention, however, the nature of the charges in this case result in a rebuttable presumption that, quote, no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. As such, the question before this court is whether the defendant has successfully rebutted this statutory presumption. He has not. Even if the defendant were to provide sufficient evidence to rebut this presumption, which he has not, the question this court must consider in turn is whether the government has met its respective burdens of demonstrating that the defendant presents a risk of flight and a danger to the community as set forth below. The government has met its burden in this regard. Accordingly, this court should again deny the defendant's motion for release. And I contest that they have not, because you're assuming, based on information that has not been vetted, has not been proven to be fact, has not, been tested in a court before a jury. So you're just assuming that because these people say these things about him, that makes him a flight risk. And I just don't think, and that's why I say it really comes down to whether or not the judge wants to let him go or not. And so it says, as the court is aware, the defendant has been detained pursuant to permanent order of detention pending trial. The defendant now moves for temporary release from custody due to the COVID pandemic. The defendant's motion should be denied. Under the Bail Reform Act, a judicial officer may, by subsequent order, permit the temporary release of a person in the custody of a United States Marshal or another appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Notably, this provision has been used sparingly to permit a defendant's release where, for example, he is suffering from a terminal illness or serious injuries. United States versus Hamilton. In support of this third request for temporary release, the defendant relies on his own recent diagnosis of prediabetes as basis for the court to grant him temporary release. The defendant alleges that this condition, coupled with other purported medical issues and the fact that he is incarcerated, places him at a much higher risk for serious complications if he were to become infected with COVID-19. The defendant, however, has provided insufficient grounds for this court to conclude that he is in the category of individuals who would have a heightened risk of severe complications from COVID-19, and his motion should be denied. The CDC has advised that diabetes, including type 1, type 2, or gestational, may put people at higher risk of several illnesses from COVID-19. See groups at higher risk for severe illness, and then they have a article from the CDC.gov that they say that they last visited on today to support what they're saying. It says, although the CDC has listed diabetes as a condition comorbid with COVID-19, not all individuals diagnosed with diabetes will suffer severe illness or complications for contracting the virus. Okay, we already know that. Notably, in discussing why individuals with diabetes may be at a higher risk for COVID-19. Okay. For severe illness from COVID-19, the CDC has explained that people with diabetes whose blood sugar levels are often higher than their target are more likely to have diabetes-related health problems. Those health problems can make it harder to overcome COVID-19. Then a site where it states that on the CDC website. To mitigate this possibility, the CDC recommends that those with diabetes continue to take their medication, eat properly, and monitor their blood sugar levels, especially if they become sick. Accordingly, those individuals whose diabetes is well managed and who do not suffer from diabetes-related health problems may reduce their risk for severe complications from COVID-19. Accordingly, a diabetes diagnosis in and of itself may not warrant release. Indeed, in cases involving serious charges, many courts, including courts in the district, have denied defendants' requests for release based on COVID-19, even where the defendant was diagnosed with a condition listed as a risk factor for severe illness from COVID-19. Then they cite some cases of people that have been denied. It says, then they talk about determined defendant. In one case, it was determined that the defendant was a danger to the community and declining a release, defendant based on COVID-19 pandemic for 61-year-old with asthma. Then another case, they said denying defendants' request for release for the COVID-19 pandemic based on defendants' advanced age and medical conditions, where defendant was charged with 2 counts of murder while engaged in narcotics. And then in another case, it says an inmate detained in MCC on controlled substances and firearm charges who had recently experienced a stroke and had high blood pressure. And then another case, bail was denied for an inmate detained in MCC on controlled substances charge, had a childhood history of asthma. And another case for an inmate detained at Valhalla on controlled substance and Hobbs Act charges with history of whooping cough. Notwithstanding the defendant's claims that he is likely diabetic, the defendant has not been diagnosed with diabetes. He has been diagnosed as pre-diabetes. In his May 1st, 2020 evaluation, note stating the defendant is pre-diabetic, which carries a meaningful distinction. Then they cite a court case, and then it says recognizing key distinction between diagnosis of diabetes versus diagnosis of pre-diabetes, noting that according to the CDC, nearly 1 in 3 Americans have pre-diabetes, and denying defendants' motion for temporary release. While diabetes has been linked as a risk factor for severe complications associated with COVID-19, the CDC has not similarly listed prediabetes as a risk factor. See people who are at higher risk for severe illness, and then they cite the website cdc.com. And then it says, as it does not carry all the symptoms and health risks as diabetes and is significantly more common condition. They say to bolster his claim, the defendant asserts that he also suffers from high blood pressure and cholesterol issues and that he is overweight, which he asserts places him at a greater risk for both diabetes and complications from COVID-19. As a preliminary matter, the defendant has not been diagnosed with hypertension, nor has he been prescribed any medication to treat high blood pressure. A review of the defendant's medical records from MCC Chicago also reflects that the defendant has previously denied having a history of hypertension. Moreover, while the defendant's recent laboratory tests indicate elevated cholesterol levels, the defendant has provided no evidence that these levels place him at risk for complications from COVID-19 were he to contract the virus. In fact, the defendant's medical records reveal as of May 1st, 2020, the defendant is currently not on any chronic care meds and does not suffer from any chronic disease issues. The defendant's contention that MCC Chicago is, quote, not taking any medical action to mitigate any of those conditions, end quote, and thus increasing his risk is without merit. To the contrary, the defendant has been regularly evaluated and treated by medical personnel at MCC Chicago for various issues since his incarceration. Indeed, since the beginning of this year, the defendant has been seen by clinical director Bree Mohan, MD, almost monthly, specifically on January 21st, February 10th, March 31st, and May 1st, and by nurse practitioners on 5 occasions, February 10th, March 31st, 5 occasions, January 17th, March 19th, March 26th, April 17th, and April 29th. The defendant has also been seen multiple times by registered nurses this year as well. With respect to the defendant's reported issues consistent with standard recommendations on pre-diabetes, then they give a Mayo Clinic article talking about pre-diabetes. It says medical personnel treating the defendant have advised him to manage his pre-diabetes, elevated cholesterol levels, and weight with dietary changes and exercise. For example, on April 29, 2020, during a recent medical appointment, the nurse practitioner discussed ways to reduce cholesterol, including smaller portions, with the defendant. Example 1 at 5. Moreover, the defendant was counseled regarding exercises he could engage in, even though he's restricted to his cell during the COVID-19 lockdown. The nurse practitioner also discussed ways to calm the defendant's mind and breathing exercises with the defendant. In addition, on May 1st, 2020, during an approximately 45-minute visit with Dr. Mohan, the defendant was counseled to do regular room exercises. I guess they misspelled lose and typed loose, so they point that out, that they are not making that mistake, that it was the report that they received that misspelled the word. Take multivitamins and B12 vitamin for nerve health. Moreover, Dr. Moham noted that he would check labs again once the defendant starts regular exercise and lose weight. While the defendant complained that he can't exercise in the small room and he can't have the diet he needs or wants, Mr. Mohan further counseled the defendant to avoid sweets and fatty food, explained about the national menu, and stated that he would provide the defendant with a calorie count chart so that he can consume a 2,000 kil diet every day per the chart. The defendant's medical records further note that the food services manager was notified to provide national menu calorie chart to the defendant as discussed, in addition to counseling the defendant on steps he can take to treat his condition and mitigate the risk of further exacerbating it. Dr. Mohan specifically noted that additional laboratory tests would be ordered at the end of June to monitor his progress after implementing lifestyle changes. The defendant's assertion, therefore, that the medical staff members at MCC Chicago are not addressing his specific medical concerns is disingenuous at best, and the court should disregard it. Nor should the court place any weight on the defendant's unsupported non-medical opinion that it only makes sense that he is likely diabetic because of the MCC's alleged lack of mitigation Given Dr. Mohan's current treatment plan, the defendant's pre-diabetic, therefore, does not present a compelling reason for release. And then they talk about a memorandum talking about pre-diabetes, which was being treated with the drug metformin, where defendant does not have type 1. So they're talking about another case there. Okay, then it goes on to say the defendant also fails to put forth any other compelling medical basis for granting his motion. As the court has recently explained, the defendant is 53 years old, 12 years younger than the cohort of older adults defined by the CDC as high risk for severe illness from COVID-19. Goes on and says, in fact, the defendant has conceded that his age does not create a compelling reason for release. And then they cite some document. It says, acknowledging in his emergency motion for bond that he is not within the highest risk age group, moreover, consistent with other courts in this circuit. And so they're basically using Greenberg's own words against him from his motion. Then it just basically goes on just saying that based on that information that they gave about him being pre-diabetic and his age, he doesn't qualify to be released because of COVID. Then it goes on talking about the spread of COVID within prisons. And they list documents. It says these measures remain in place and MCC Chicago continues to do what it can to identify infected inmates and separate these inmates from inmates who have not contracted the virus. To that end, the government has been advised that MCC Chicago recently received a rapid test machine and has started to perform mass testings on units 24 and 23, which are open dormitory units without cells and not where the defendant is housed, according to legal counsel at MCC Chicago. As a result of the mass testing of these dormitory units where the lack of cells makes social distancing more difficult, as of May 1st, 2020, 102 inmates and 25 staff members in total have tested positive at MCC Chicago, and all of the inmates have been isolated from other inmates until they have been cleared by medical staff under CDC guidelines. 94 of the 102 inmates who tested positive were asymptomatic. Legal counsel at MCC Chicago has provided the government with the total number of inmates who have tested positive to date. The figure, however, does not account for inmates who have since recovered. According to legal counsel at MCC Chicago, the Bureau of Prisons website accounts for such recoveries and reflects the net number of inmates currently infected with the virus. As of May 4th, 2020, the Bureau of Prisons website indicates that MCC Chicago currently has 97 inmates with COVID-19. In any event, despite growth in positive cases at MCC Chicago, has reported no deaths as a result of COVID-19 infections, and there is no evidence that the medical staff has been unable to adequately handle the medical needs of inmates who contract the virus. Finally, the reasons set forth in detail below, the defendant's continued insistence that conditions such as electronic monitoring from home confinement and restricted computer use may be put in place to monitor the defendant lends no weight to the question before this court with respect to his temporary release. Whether the defendant has offered a compelling reason for the court to release him given the pandemic. The defendant has failed to do so according to this court and should deny his motion. Okay, so then they go back to what I've already shared with you about the original magistrate saying that he should be held until trial. Then Then it goes on to talk about on April 7th, in considering the defendant's emergency motion. I think they already talked about that earlier. More recently, on April 20th, 2020, the court further found that the risks associated with the defendant's release have not changed. The defendant continues to downplay the risk that he might flee. We already talked about that. The court further emphasized that the defendant currently has a significant incentive to flee, given that he is now facing serious charges in multiple federal and state jurisdictions, and that even aside from the risk of flight, the risk that the defendant would try to obstruct justice or intimidate prospective witnesses has not dissipated. And once again, that is, they have no basis to prove this on, so I don't know why they're allowed to keep bringing that up. Under the guise of seeking release because of COVID-19 pandemic, the defendant attempts to relitigate for the fifth time the judge's motion that he's not a danger to the community. Defendant asserts the ruling does not appear to consider whether there are any set of conditions which could reasonably assure the court that he would appear and would not be a danger to the community. The defendant wholly ignores that whereas here there is probable cause to believe that the defendant committed offenses involving minor victims, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. Moreover, the presence of an indictment returned by a duly constituted grand jury conclusively establishes the existence of probable cause for the purpose of triggering the rebuttal presumption. To rebut this statutory presumption, the defendant must come forward with evidence that he does not pose a danger. Wearing mask, he could conceal his face in a manner that would not be deemed at all unusual, thereby going unrecognized. Defendant's assertion that GPS or electronic monitoring would ensure against any risk of flight is unavailing, given that the defendant could remove or otherwise alter the electronic monitoring bracelet. Now, I know a couple of people that have had electronic monitoring devices, and the second they leave their house, a signal is sent to the people that's monitoring them, okay? And police are alerted, and they are alerted quickly. And I'm sure in the case of R. Kelly, they would definitely be right there. No doubt about it. It says, notably given the, okay, I read that. Although its removal would alert pretrial services, law enforcement's response would not, even under the best of circumstances, be instantaneous. The defendant may therefore be able to evade law enforcement for some time before being found. Then they cite some case discussing potential ineffectiveness of electronic monitoring, discussing the futility of conditions such as electronic monitoring in the case, and citing cases. In addition, the defendant's repeated proclamations that he has no financial resources available to him or individuals willing to assist him monetarily or otherwise is contradicted by past and recent events, in addition to the defendant's continued access to his own financial resources in the form of royalties. The first quarter of 2020 alone, the defendant received over $200,000 in royalty proceeds. Because of his notoriety, other individuals, acquaintances, and strangers alike continue to express their interest in providing financial support to the defendant. For example, after the defendant's arrest by Cook County in Illinois on multiple charges related to the abuse, some fans offered to pay the defendant's $100,000 bail, believing that the defendant, who had not yet posted bail and remained incarcerated for multiple days, was unable to pay. Then they cite an article that came out, and it says, and then they talk about the, what what was the lady's name that owned the school that posted the money? And then remember she went and tried to get the bail returned or something, but then she posted on social media that he had paid her the money back plus 10%, and then showed the money order and everything else. While the Department of State has issued a level 4 advisory that individuals avoid travel, and airline travel has been significantly reduced due to the pandemic, it is certainly not impossible, as the defendant contends, for individuals to fly by air. For example, the Transportation Security Administration reported that on May 3rd, 2020, 170,254 travelers were screened for airline travel. And then they cite the story that came from. The Chicago Tribune. Then they said, Chicago Tribune reporter Will Lee, who said on Twitter, quote, "A court clerk just told me their office was receiving calls from female R. Kelly fans wanting to know how to post bail for him. The love is real, I guess," end quote. In addition, as the defendant's counsel is well aware, acquaintances and fans of the defendant have used social media to try to secure funds for Kelly's benefit. Indeed, one of the defendant's attorneys, Douglas Anton, has himself appeared by telephone on at least 2 occasions on one such individual's YouTube channel. And during these appearances, Mr. Anton either advised those wanting to send money for the defendant's defense to do so to his attention, or participated while requests for donations for the defendant's defense were made by the host and others. And then it says, see, Douglas Anton, R. Kelly lawyer, follows me on Facebook, and he came by my Facebook Live and talked about Kels. At approximately 3 minutes and 35 seconds, 3 hours, 35 minutes of the video, Mr. Anton participates by telephone. At approximately minute 15:45, Mr. Anton advises that while he is not requesting donations, those who wish to donate may send funds to his office. Up at Night with Deejay Tyson, timestamp 47 minutes. Doug calls in and Dana calls Doug and lies to Kel's attorney. Available, and then they give the YouTube. Host and fans request donations be directed care of Mr. Anton, and Mr. Anton calls in to participate beginning at approximately 48 minutes 18 seconds. Each of these videos received about 5,000 and 4,000 views respectively, while the potential donations referred to these videos were described as being for the purpose of the defendant's defense fund and would presumably not be provided to the defendant. This nevertheless demonstrates that others on the defendant's behalf can use social media to rally others, even strangers, to provide financial support for the defendant if necessary. As previously proffered by the government, given the defendant's history of maintaining funds in bank accounts bearing the names of other individuals, then it says, see government opposition to defense motion to reconsider, blah, 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 stating that the government's investigation has revealed that earlier this year, the defendant redirected royalties to the bank account of a childhood friend. The defendants claimed that his ability to secure resources to flee is an impossibility, is simply not credible. Putting aside the defendant's ability to physically abscond, he has also failed to rebuke the presumption that he poses a danger to the public by, among other things, intimidating or unlawfully persuading a witness. The stakes in a criminal case are high, and temptations of perjury, subordination, and intimidation are ever present. And then they cite another case, United States versus Sendon. And it says, even if this court instructed the defendant to refrain from contacting potential witnesses directly or indirectly, there would be little ability for the government to adequately police the defendant's compliance with such an order while on release. As this court has recognized, there would be no ability for the government to prevent the defendant from receiving visitors or using a concealed cellular telephone or computer to contact individuals with the goal of interfering with witnesses himself or directing others to interfere with witnesses on his behalf. Proffered conditions of release cannot stop a defendant from using an unauthorized telephone or digital device to contact potential witnesses or from inducing someone else to do so. The defendant, in essence, absurdly suggests that this court must first wait for the defendant to attempt to commit obstruction in this case before his detention is warranted. This is clearly not required under, then they give the code, the U.S. code, which, given the charges in this case, presumes, subject to rebuttal, that the defendant is a danger to the community. Then they basically repeat everything that they already said. Then they talk about the charges. Defendant is alleged to have committed, while awaiting trial in Cook County, based on crimes charged in the Eastern District of New York and the Northern District of Illinois indictments. While the defendant is presumed innocent, the law does not require the court to ignore. Okay, so they said that already. The defendant proposed conditions. They talked about that already, why they don't think that would work. In any event, the court has recognized the government has proffered evidence that the defendant has demonstrated a clear pattern of interfering with potential witnesses in the past and has also engaged in behavior reflecting his ability and willingness to engage. And basically, they keep saying that, but they haven't provided any evidence that we can see in any of these motions. So maybe there's something that they presented that Steve Greenberg doesn't have access to, because they keep saying that they presented evidence. The defendants claim that he never did a single obstructive thing related to these proceedings, including with respect to certain of the Jane Does, or that the idea that Mr. Kelly would now obstruct anyone is folly, are contradicted by inter alia the evidence proffered by the government regarding the defendant's decades-long presumptive tactics aimed at discrediting potential witnesses in future cases against him. And they give like a lot of numbers and codes and document numbers. It says his previous intimidation of Jane Doe number 6, which is Faith, as a result of her commencing a lawsuit against the defendant, docket numbers, motions, blah, 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 and the defendant's at times successful attempts to circumvent the restrictive conditions placed on him aimed at monitoring his activities while he has been incarcerated. On the instant charges, government reply regarding motion to preclude, blah, blah, blah. Indeed, given the defendant's willingness to bypass the strict conditions placed upon him while he is incarcerated, it is more than reasonable for this court to find that there is a serious risk. So evidently, there's some evidence somewhere. And I guess if I research these docket numbers and maybe I can find what it is that they're referencing, because they're not spelling it out here. They're just telling where the judge can go locate this information that he has indeed tried to intimidate people. And actually, I think they may be referring to, because it seemed like in one of the things that I read, and it might have been in one of the actual indictments, where they talk about that website that somebody had threatened to put up, where they were going to name all these people, and that he had these people that were, these men that were willing to say that they had slept with Faith even before she got involved with R. Kelly. That may be what they're referring to, because I do remember reading about that in the documents. But they never did prove that that was him that created the Facebook page, or that that was him that created this website that was supposed to reveal all this information on the people that appeared on Surviving R. Kelly. So how they can hold that against him and they have no proof that he even did that is beyond me. So it says, finally, the defendant's suggestion that there is parity between his circumstances and those of the co-defendants charged in the Northern District of Illinois indictment, whereas here the defendant is facing, among other things, prosecution for serious crimes in 4 separate jurisdictions, numerous charges related to the assault and exploitation of minors, and is subject to multiple charges related, multiple mandatory minimum sentences if convicted of certain charges in the Eastern District of New York, Northern District of Illinois, respectfully lacks all merit. Moreover, the Northern District of Illinois Court's determination regarding the defendant's co-defendant's bond should have no bearing on this court's findings regarding the defendant's request for temporary release. Here, the government has and continued to object to the defendant's release, and this court has made repeated findings that the defendant's detention is warranted. The defendant's then assurances that he would not attempt to flee or obstruct the proceedings holds little weight, blah, blah, blah. Just say the same thing over and over. Even if defendant's proposed conditions are sufficient to rebut statutory presumption, which they are not, defendant's detention is still warranted because, for the reasons articulated above, the government has met its burden of persuasion, blah, blah, blah. Conclusion, for this reason stated herein and in the government's prior submissions related to the defendant's detention and history of obstruction, the defendant's third emergency motion for release should be denied. And I thought somewhere in this thing, they had listed his blood pressure readings, and did I skip over that? Somewhere in here, they had listed his blood pressure readings, and they were talking about the one day he was having a panic attack and his blood pressure was like 150 over 100 and something. But then on all the other times that he's been seen by the nurse, his blood pressure has been, normal, like 125 over something. But they had like 10 different blood pressure readings. And I can't find that now. I don't know where I saw that at. Oh, here it is. So it says, the defendant had a recent blood pressure reading of 150 over 95 on April 7, 2020. The defendant was being evaluated for a panic attack where he was visibly upset at the time. And it says other blood pressure readings between July 15, 2019 and January 15, 2020 reflect significantly lower readings: 125 over 82, 125 over 75, 132 over 92, 121 over 85, 122 over 74, and then they tell where they can find that at on the medical records. And then it says, in any event, even if the defendant were diagnosed with hypertension, this would not necessarily warrant release while hypertension. And then I read that part to you guys. Somehow I missed the blood pressure readings. R. Kelly blood pressure better than mine, I'll say that much. Okay, so that's it. They basically just ripped Steve Greenberg's motion to pieces. And then that whole part about Doug Anton, you guys know I have said it once, twice, and again. There was no way I would have a lawyer on my team that is on YouTube talking to YouTubers, coming between YouTubers that are arguing with each other. There is no way in hell that would take place. And then, so now it's coming to bite them in the butt. Once again, R. Kelly did not ask anybody to raise any money for him. So why is there even a defense fund? Where is the accountability for this defense fund? I think at this point, we need to know how much money has been raised Is that money in a trust account? It's not a trust account. It's called something else, but it's like a trust. And basically, Doug Anton wouldn't be able to withdraw that money. And there needs to be an investigation about that dollar for the king and whether or not all the money that it has been collected is actually going to Doug Anton. And so it's going to be interesting to see how they deal with that part of this opposition, where they actually talk about Doug Anton calling into these YouTuber shows, which I have said all along is the dumbest thing to me, but people said I was wrong. But anyway, that's it, guys. Let me know what you think. Leave your comments below, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.